Well, good afternoon, everybody. This is Ernie Garcia, landlord attorney, and I'm happy to be back. Sorry that I missed you guys last week. I was in court. I had a few things I had to take care of involving some civil litigation, but I am back for the month of April. I hope you all are having a fine April. While we're waiting for people to log on, I'm going to turn on my light. All right, that's a little better. So today we're talking all about repairs on your rental property and what you can do whenever you're faced with these repairs. I get a lot of landlords who come to me and just aren't really sure how to get the tenant to pay for repairs. So I want to talk about a couple of things first, a couple of fundamental things. Let me get my giant drink out of the way here. I want to talk about a couple of fundamental things when it comes to making sure that as a landlord, you have the right and you have a good mechanism for getting your tenants to pay for repairs that they are 100% responsible for. And so the key right from the start is, what can you actually charge them to repair or replace? So as many of you know, you are limited in the kinds of things that you can charge. You can't charge them if things break from normal use or from normal wear and tear. Anything that is ordinarily, broken or that ordinarily comes to, some kind of end in its life when it comes to your house that you would have to repair anyway, you simply can't charge that to the tenant. So anything that exceeds normal use or exceeds normal wear and tear, or that was, broken or damaged through the negligence of the tenant, those are the kinds of things you can charge. So make sure that you are limiting repair costs that you're charging to your tenants to those things. Another thing I like to talk about before we really get into the depths of something like this is the idea that, Ernie, I just let the tenant do all the repairs themselves. And so I call them on it. I tell them, look, you broke it, you fix it. And I'm happy with you doing that. Hey, James, good to see you. Here's the thing. You're the only one you can trust 100% of the time. If you trust your tenant to make a suitable repair that you're going to be happy with, then yes, you can take that risk and have the tenant simply complete the repair. That might be the easy way for you to do it. But sometimes, especially when you just don't know, sometimes a tenant will go and attempt to repair something, and they end up causing more harm than they end up doing good. And so if they're going to do a patch job that you're just going to have to go afterward and fix up the correct way later, they didn't really save you any time, and they certainly didn't save you any money. And so unless you are certain that your tenant is actually, likely to complete a suitable repair, you're always better off hiring your own contractor to get in there and get the job done and then charging that fee to your tenant. So then we come back to the original topic. How do you get your tenant to cover these repair costs? Well, I'm going to go in order from the worst way to do it to the best way to do it. And so right from the start, the worst way to do it is to sue the tenant after they have left. And many of you are like, well, I've got a pending claim right now. They damaged my property. They did X, Y, and Z, and I've got a mountain of receipts that I've got a good case. I've got a great path toward judgment. The problem is you've had to pay everything up front, and now you're hoping to collect from this tenant. And collection can be complicated. First off, you got to be able to know where they are so you can actually reach them with a lawsuit. And then secondly, you got to know that you have, a valid method of collecting from them, because some tenants just don't have the means to pay the judgment. And depending on your state and your ability to collect these judgments, you might be really limited in what you can collect after the fact from your tenant. For example, in the state of Texas, you can't collect or seize property from a tenant that is otherwise exempt. Among those things would be their homestead. So they might own a home now, but you can't foreclose on that home, even if you've got a $30,000 judgment. And so you say to yourself, well, I know they've got a $30,000 car, free and clear, totally paid for. They used to brag about it all the time. And so can I seize that car and have it sold at an auto auction? And the answer is no, probably not, because they are also entitled to a car for each driver in the household. They're also protected for an individual up to $50,000 worth of their personal property, and for a family, $100,000 of personal property. And so unless they have means beyond those numbers, and unless they have property in excess of those limits, it might be difficult to collect after the fact. Not impossible. Certainly there are tenants who leave and who leave damage, who have the capacity to pay. But that's your first hurdle, that I paid everything up front and now I got to get them. Now I've got a successful judgment. I've got a worthwhile judgment, but now I got to find the money to get paid. So a better way to do it would be to make sure that you've limited all damages to the value of the security deposit or less. And one way to do that, one way to accomplish that, is with regular visits to the property. If you are only seeing the property at the beginning, when you're handing the keys over, you say, goodbye property, I'll see you in a year or two when I recover possession again, that's a big mistake. You need to make sure that you're on the property on a regular basis to make sure that the property is still in good working order and that the tenant hasn't caused damage that requires repair. So that if all the damage is limited to their exit, you're likely to minimize those damages to the value of the security deposit or less. But it requires you being on the property and making sure at all times that the tenant is not otherwise harming that property. So the next best way to collect is from the security deposit. Unfortunately, sometimes the damage amount exceeds the value of the security deposit, and so you have a shortfall that you can only collect with a subsequent lawsuit, and then you have the same problem that we talked about already, is collecting after the fact. So it's good that you have some amount in the security deposit. It's good that you limited that amount because you were diligent, but if it turns out that the damages exceed the deposit amount, you have the same problem as before where you're chasing that tenant for collection. So the absolute best way to collect from your tenants for the repairs is during the tenancy. If you've been around long enough, you've heard me say it over and over and over. Once you find a problem, you are repairing the problem, giving notice to the tenant that they are on the hook for that problem. Again, if it exceeds normal use and normal wear and tear, it was caused by the negligence of the tenant, and you can prove that, you're serving them with notice and you're giving them a bill and say, look, this cost me $500 to repair. Please take care of that in the next 10 days or the next 2 weeks or with your next rental payment. And then enforce it. Come after it because it's probably in your lease in black and white that they are responsible for these kinds of damages. And if you've got an application of funds clause, you can technically subtract that amount from the next payment of rent if that amount is short of the grand total, the amount of the repair and the rent and any other things that are otherwise owed. You can pay to non-rent obligations first, and then the rest of it to the rent. And if it turns out the following month they haven't sent enough money to cover the full balance of what's owed, you can apply it this way first and then say, look, you've got a shortfall in rent, and then take it up with the court thereafter if they do not cure that default. I hope this is helpful because definitely it is easier to collect from a tenant when an eviction is on the line, when they still got multiple months left, they had no expectation of having to leave in the middle of their lease, they're likelier to pay for what is owed. Additionally, if it's just one thing wrong, they're likelier to cover it quickly, as opposed to 15 things that are wrong at the end of the lease, which is why it's a terrible idea for them to wait for them to leave before you begin documenting and begin charging them for these fees. You always want to do it during the tenancy when they're the likeliest to pay it and when there's the least amount of damage. So I hope, landlords, this is helpful to you. I'm starting to see some contributions on the chat. If you've got a question that you'd like to ask me live while I'm here, please contribute it to the chat. I've got a handful of questions that were submitted to us through email, through our Facebook group. And so if you've contributed a question, I will get to it and give you an answer. But if you are just joining us now and you haven't contributed a question yet, feel free to add it to the chat and I will do my best to answer everybody's questions while I am live. Joy Stanchik writes, had a tenant install an EV outlet without permission. Can I charge him for my electrician to check his work and for the permit required? Absolutely. Check what your lease says. Your lease should have a 100% prohibition on the tenant altering any part of your rental. If that's the case, and they didn't at least seek you out, they didn't get your prior written approval, then yeah, absolutely, this is 100% a violation of the lease, and it is 100% damage to your property. You definitely should have an electrician come, because they might have, like with that botched repair, they might actually have made things worse and not better. So you want to get this in, you want to get it permitted so that you're not hit with a fine later, or worse, you're not hit with some kind of electrical fire that damages your property well after this tenant has gone. So yes, find the provision in your lease that prohibits this activity, issue written notice, get your electrician, issue a bill, let them know, look, you were supposed to follow these directions of the lease, you failed to do it, you are currently in default, and now I'm going to seek payment for the harm that you've caused. Thank you, Joy. I appreciate that. And you are very welcome. James, if they don't pay after several notices, would you start eviction? Yeah, you definitely would. Again, James, if you're getting short payment and you have an application of funds clause, you might do it as early as the next rental month. Now, I don't know that I would run to the courthouse after that short a period of time, but I would certainly issue notice after notice after notice. And I tend to preach a 3 strikes and you're out philosophy for this. And so if you give the tenant an adequate amount of time and they're simply not getting it done, then you can demonstrate to the court that you're evicting them not because they owe you money, or not only because they owe you money, but because they simply cannot be trusted to follow the lease. You gave notice after notice after notice, and they still refused to cover these costs, then yes, I would strongly suggest before too long, I wouldn't wait more than 30 days, but certainly, give notice and follow through, give them an opportunity so that you can demonstrate to the court that you were fair in giving an adequate amount of time for them to pay. And if they simply don't, then that's probably a good time to move forward with an eviction. Again, 3 notices or more. I wouldn't say 10 are required, but you don't want to just go after your first notice. Probably want to give 2 or 3. 3 is a good number that the courts are pretty comfortable with, but 4 or 5 are adequate as well. Thank you, James. Janice Sanchez. How much is good amount of deductible tenant is required to cover before repairs? That's an interesting question. I'm not sure what you mean by deductible. If you're having if you filed an insurance claim and they are otherwise 100% responsible, then they're 100% responsible for the cost of the claim. And that might not just be the deductible. Your insurance company has, by paying the claim, now has a claim in that exact value, not just the deductible, but for the full value of the claim against that tenant. You have a claim for the deductible because those are your costs. And so you can charge them that deductible, but the insurance company could actually come after them for the rest. Now, they don't usually, but that's technically what's gone on when an insurance claim has been issued. Now, remember, you got to prove that the damage was caused by something more than ordinary use or normal wear and tear, perhaps by the negligence of the tenant. if not their, outright direct misuse. James, when you say written approval, does a text message count? Well, James, that's going to depend on what your lease says. I always refer people back to the written document. What does the lease say for notice between the landlord and the tenant? Does the lease already allow text communication? Text is not my favorite. I prefer email. If you have a tenant portal, that's also a good method because it can log time. Of course, the old-fashioned written letter. But text can get kind of funny. Phones get lost. And so, yes, maybe. But my preference is regular email or your tenant portal because it's easier to show to the court what the communication was. Also, people are a lot less formal in their communication when they text. I think emails are a little better. And of course, regular letters are usually the most clear. I would personally stay away from text, but it could count if it's in your lease. James, you're welcome. Thank you, as always, for contributing. James, I appreciate you asking your question. So now I'm going to go to the prefab questions that I've got from many of you already. I've got 11 questions. Let's go. This is from Janice. She's on our email list. She says, greetings, I'm new to your channel. Welcome, Janice. What are the must-haves in a pool addendum? Liability, waivers, rules, planning to rent my house in Galveston County. Thanks for your feedback and helpful webinars. So I actually had this question just this morning in a consultation. There are a couple of things, three really main things that I always tell landlords are a good rule of thumb, rules of thumb, I guess, to have whenever you've got a pool. Number one, you gotta have a fence. Make sure that the pool is locked in and the property is surrounded by a fence because you don't want to have what's called a nuisance, an environmental or constructive or just some hazard that's open air that any little kid could just wander into and fall into your pool. By having a fence, you no longer have that as a claim. Somebody would have to jump the fence, which would be trespassing, and most little kids can't do that. If a teenager does that, again, trespassing, you've got that minimum protection, and you can't protect against vandalism or criminal acts, but you can protect against innocent children wandering onto your property with a fence. That's one. Number two is a good lease. And your lease should have disclaimers of liability for things like swimming pool or for really any injury that could happen to the tenant or their guests. And that's important. Do you have a liability waiver in your lease that already applies to the situation? The last thing is to have a requirement for your tenant to have, actually, let me jump back. Because it should go without saying, but part of your lease should include an addendum that has to do with use of the pool. And definitely in your house rules, you should map out proper use of the pool, who can use it, the fact that children must be monitored at all times, safety rules for the use and maintenance of the pool while the tenant is in possession. And so by having these, they strengthen your lease, the liability waiver, but also your own house rules or specific rules having to do, or an addendum, however you do it, specific rules having to do with the proper use and maintenance of the pool. By having the tenant agree to these, another layer of protection. Number one, they agree you have no liability, that they assume responsibility for the proper maintenance, monitoring, and use of the swimming pool. That's a huge help. The last one is insurance. So you want to, number one, require your tenant to carry a liability policy, not just for them, but also for the people they invite. Or if their teenager is having a swimming pool party and you happen to be inside watching the game and something goes terribly wrong, you don't want to be on the hook for that. You want to make sure that your tenant has a liability policy in place that could cover events when they are failing to adequately monitor their children around the pool. Or if, for example, somebody's running, they slip, fall, crack their head open, you've already let them know this is not acceptable behavior and should not occur. Make sure you're preventing this from occurring. You assume these responsibilities if you breach these simple rules. So liability insurance is great from the tenant, but also you should have liability insurance, because even though you've got a liability waiver and you've got a liability insurance from your tenant, you can't always rely on those things for a couple of reasons. Number one, their insurance could lapse and boop, that goes out the window. Even though they're required to do it, yeah, that's a breach, but that lapse could be an expensive lapse that you have to deal with. Number two, your liability limit in the lease only exists for things that you didn't do or you didn't cause. What if you accidentally went to visit the property and accidentally left the gate open and in wanders a little kid? Could you be said to have liability then? Yes. Did you mean to do it? No. Did you actually do it? Yes. And so you would likely have cause for concern. And so you're going to want to have your own liability coverage in the event that you negligently or mistakenly do something that results in harm, where your own liability waiver or your own tenant's liability coverage will not suffice. So you're going to want a fence, you're going to want a good lease, you're going to want good insurance. Those are the big three that I recommend if you've got a swimming pool. So next question. Anselmo asks, I have a tenant no longer inside the property. He's living in the car, also on the property. It's in the driveway, in the backyard, to be exact. I have keys to the house. I was planning on boarding up the house so he doesn't have access to the interior. What rights do I have? Do I need to file for eviction? Okay. As long as he's on the premises, he's on the property. It doesn't matter that he's not in the house. He's on the property. And so living in the car means, yes, he's still living on the property and you must evict him. Send him a notice to vacate. If you've already sent a notice to vacate, file that eviction. You're going to ultimately need to execute a writ of possession. So the constable comes, ushers him off the property. You've got to sign judgment. You've got to sign order in that writ, giving you absolute possession. And on that day, you're calling a tow company to have that car towed off your property. This tenant is no longer allowed to be on the property. In his car, outside of the car, doesn't matter. He is still on the property. Get him evicted. Okay, we've had some more questions pop up. I'm here. Thanks for the live. This is A. Brown. All right. I had an incident last year. This is Brown. I had an incident last year in September 2024. Tenant put a hole in the tub. I had to use my landlord insurance. We are in the process of eviction. So the question is, how did that hole get there? Is it possible that the hole got there through normal use or normal wear and tear? It is mathematically possible, but it is very likely that that hole got there through misuse or negligence, right? And so I don't know how it happened. I don't know what evidence you have of this misuse, but my guess is this probably didn't happen through normal use. So can you charge the tenant? You're in the middle of the eviction process. What did it cost you out of pocket? You can charge that. Unfortunately, because you're in the eviction process, I mean, what else does this guy have to lose? You're already kicking him out. Still, I would issue a bill to them so that it's clear that, among other things, this is going to be added to the laundry list of deductions from the security deposit. So yes, they're on the hook for this repair if you can prove that the damage to the tub was caused by more than ordinary use, more than normal wear and tear, probably negligence. I would send that bill and then ultimately put it on the laundry list of things you're deducting from the security deposit. Joy chimes in again, says, sorry, off topic. Have a question about billing for utilities. I'm currently billing a tenant for water usage, but what if a tenant won't pay? Can I use an application of funds clause to evict if necessary? Technically, you can, but I would look and see what your lease says about these utilities. Do you have specific mention in your lease that the utilities are chargeable? Do you explain how they are charged? Is it a flat fee? Is it per square footage? Do you have a monitor? And then my question would be, is there any way in the future, because you can't do it for this one, is there any way you can get the tenant to simply get these utilities in their own name, so this is not an issue for you in the future? Because you certainly can't shut off the water, but a water utility company does have that authority. Can you apply funds from the application of funds clause? Read your lease. Do you even have an application of funds clause? If so, then technically, yes, you can apply it first there and say, sorry, tenant, you are now short on your rent. Please pay within a certain amount of time, or you will be, you are already in default. You will continue to be in default. And here's where I might suggest multiple notices, mostly because they technically paid some rent. It's not going to be, unless it's an enormous water bill, it's not going to be, majority of the rent that remains unpaid. So I would issue multiple notices over the course of that month. But ultimately, if they're simply refusing to pay or unable to pay, then yeah, you're probably going to have to ultimately move forward with an eviction. All right. Jose Lira writes, I have a rent house and two very nice Catholic nuns are interested in renting. I'm delighted to rent to them. However, in speaking with them, they will not be the ones paying the rent, but a Catholic church would be responsible for the rent. The rent is only for dwelling purposes, no business, no gathering services. Here's my question. Would you still do a background check on each person? And would the church administrator be on the lease, since they would be responsible for the rent? How would you handle this matter? Thank you in advance. So definitely, whoever's signing the lease is on the hook. And if these two people are adults, you do a background check on everybody. And so the title of an individual is not enough. Now, sometimes you have an individual who is maybe a very elderly person, or someone who lacks capacity. Those people probably don't have to sign your lease. They can be occupants. But any able-bodied adult who is otherwise engaged in an occupation, and nuns are engaged in an occupation, a service to a nonprofit for sure, they're subject to a background check. And it is not only necessary, it's protocol. You don't want to give special treatment to certain individuals that you don't offer to others. If your policy is, I do background checks on all the tenants, that includes nuns, make sure you're doing it. I'm not saying you're going to find anything necessarily harmful, but it is necessary. Now, as far as who is on the hook, make sure that the entity or the individual who's signing has some skin in the game. You're saying that the church is going to pay for this. Make sure you can confirm that the account is a legitimate account. I'm not saying that anything nefarious is going on here, but when only an entity exists, you want to make sure that that entity is a bona fide entity. I sometimes get situations where landlords have signed where an LLC is the tenant, but that the adults living there are just occupants. Well, that's a terrible idea, because if you're going to go after anybody and only the LLC is there, and the LLC turns out to own nothing, you have no teeth in any claims you might have. And those tenants might do some significant damage economically in non-payment of rent, and ultimately in damage to the property. So you always want to approach contracts that are signed by entities with a certain degree of scrutiny, and be careful. Always do a background check, and then make certain that the entity that has any part to do with a lease is a bona fide entity. That's my advice in this situation. Joy Stanchik writes, thanks. You're welcome, Joy. Number 4, Catherine Maliki asked, regarding ESA, it seems ambiguous as to 4 or less doors, self-managed, single dwelling, or can be 4 or greater doors. Can 4 or greater doors be duplexes? Must you, the owner, live on the premises? Does this 4 greater doors ambiguous law include service animal exclusion? Catherine, I think you are referring, I'm just taking a guess here. I'm pretty sure what you're referring to are the potential exclusions that exist from the Fair Housing Act. And so I want to read what is generally applicable in the Fair Housing Act. So in Texas, some landlords are exempt from the Fair Housing Act. Those include those who are renting out owner-occupied buildings with 4 or fewer units. So if you're renting out an owner-occupied building, you occupy one of the units within that building, and there are 5 or 10 or 15 units associated with that building, this exclusion doesn't apply to you. If there are 4 or fewer, so you ask about a duplex, if you're living in one, you are not subject to the Fair Housing Act as long as it is an owner-occupied building of 4 or fewer units. Okay? It also doesn't apply for homes sold or rented without a broker. And it doesn't apply to housing operated by religious organizations or private clubs. So no, none of the elements of the Fair Housing Act would apply, including service animals. So if these exclusions apply to you, you don't necessarily have to abide by the Fair Housing Act. However, I always recommend that it's a good idea to just get used to it and get used to this, because the law could change, and you want to make sure that you already operate under the Fair Housing Act and are not having difficulty remaining in compliance. I know we have a question in just a little bit about ESAs, which I'm going to get to in a bit. First, from Stacy Meeker, I really got a kick out of this. Just a thank you today, Ernie. It's so nice of you to answer questions from all these landlords. I think this group is wonderful. Thank you for putting this together. All the feedback from other landlords, as well as from you and your staff, have been tremendous help. I don't have a question at the moment. I just want to say thank you. Well, Stacy, that is extremely appreciated. I very much love it when people appreciate the time and the effort that we put into, helping people out. I'm here to offer whatever help I can give, and I know many of you come back over and over. And so, yes, I appreciate warm thanks always, and certainly I will continue to do this. And we just got from Joy, amen, Stacy. Yes. So let's proceed. Isamar Castillo Salande asked, when applicants have an ESA certificate, what can be done to ensure against damage from this ESA certificate? So Isamar asked 3 questions in one, so I'm going to answer that first one. It says, considering that the pet deposit is not allowed, how can I protect myself from someone who shows up with a valid documentation for an ESA? So remember, the document alone is not enough. You have the right to confirm its validity, which means you call and check, is this a legitimate thing? Is this person really under your care? And do you legitimately state that the animal in question satisfies this medical need? So let's assume that that's true. How do you protect yourself from this pet? Because the truth is, not every pet's going to cause damage to the property, but for those who do, it goes right back to the original topic from before. You can wait until they're gone, worst option. You can see that the damage is collected from the standard security deposit, not as bad an option, but still not great. Or you can regularly visit the property, and if you can tell that someone's been gnawing on the wooden stairs. That's not normal use. Someone's been peeing on the carpet. That's not ordinary wear and tear. And so if you can already detect the damages there, go in, say, this is damage. This was not here before. And I know this because I recorded the condition of the property before you ever took possession. This was clearly caused by your pet. I am going to repair it, but you're going to be given a bill to cover those costs. You want to make sure that you're doing that during the tenancy. And if their pet does it over and over and over again, remember, for each incident, you're issuing written notice because it is a default. So even if they are paying for these repairs, you can evict them if they continually destroy or continually damage your property. You want to protect yourself, issue notice, conduct the repair, charge the tenant. And if they do it repeatedly, you got to get rid of them. Because you're not evicting them because they have an ESA. You're evicting them because they are not controlling their ESA from damaging your property. Second question. How to write a TREC form, special provisions that flood insurance is required. Now, TREC is the Texas Real Estate Commission. TREC does not offer any leasing forms, none. It's a common misconception. The Texas Realtors lease is not a TREC lease. Texas Realtors is a private company. It is not the Texas Real Estate Commission. So if you're asking, how to include a requirement, your lease may already include it, but you are allowed to add in your own house rules or your own special provisions the requirement for the tenant to purchase liability insurance. If you need assistance constructing that, come see a licensed attorney. But otherwise, it's just not that complicated. You just add the terms to your special provisions requiring that they do it. Make sure you discuss this beforehand, before the lease is ever signed, so that it is clear not only should they purchase liability insurance, but they should name you as an additional insured. Now, flood insurance, that's going to be a little more complicated. I don't know that you need it to be so specific, but definitely they should get renter's insurance to cover their own personal property, whatever it covers, fire, flood, theft. But you can encourage them to get insurance for their own personal property and let them know, look, my insurance, nothing that I buy covers your stuff. Okay. If a person breaches a contract and allows somebody like a boyfriend or girlfriend who is not on the application to live on the property and there's physical or domestic abuse, how do you protect against that? Well, number one, you have no liability for the criminal acts of third parties, zero. So you don't have to worry about them bringing somebody on and harming that individual. You don't have liability. The greater risk is the liability of damage potential to your property. And so you protect yourself against it by monitoring the property. And if you find that some unauthorized occupant is there, you issue notice and say, look, you got to get rid of this unauthorized occupant. But as far as having any liability for physical violence to the named tenant, you have none. You do not have to cover or protect a tenant from the criminal acts of third parties. Okay. James writes, I had a situation where several people wanted to pool their money and rent a 2-bedroom apartment. Is there a legal way to deny the application based upon the number of unrelated persons? Not really. People don't have to be related. But if you have another basis, a perfectly legal basis to deny their claim, maybe the reason they're doing this is because they simply, each individual doesn't have the requisite earning capacity that you require of each individual applicant. That might be a valid basis to deny them. But the fact that people are pooling money together, I don't think that alone, or the fact that they're not related, I don't think that alone is a good enough reason to deny them access to the property. Again, if you've got some other basis where that makes them ineligible because they don't meet certain criteria, that's a much better reason to deny someone a rental. A. Brown writes, thanks, Mr. Ernie. Truly appreciate your time and effort. You're welcome. Janice Sanchez writes, is recommended to convert rental property to LLC, assuming it's paid off. That's certainly one thing you can do, but that's not the only mechanism for protecting your property. An LLC is good. You could also enter into a trust. Some of this gets beyond what I set up. I can set up a single member LLC, but I don't set up a series LLC. If you have multiple properties, you might want to start a series LLC. You're probably going to want to consult a business law attorney for how to set up and maintain and continually use a series LLC or a trust. That's just not something that we do. But yes, you want a hedge of protection around your property and distinction from your personal assets. An LLC is one excellent way of accomplishing that. James writes again, thanks. James, you're welcome. Moving on, M.A. Crumby asks, would you cover issues with a tenant writing the wrong payee name on rent checks? The landlord's business name listed in the lease, who payment should be made to, and it's also on a fridge magnet that I leave in every rental. I accepted quite a number of payments from her with the apartment complex name rather than the landlord's business name until she started pulling names out of the air. Sent a notice requiring compliance on payee names shown on rent payments, got a letter back from her stating she didn't think there was a problem, that I should accept her checks as written. I sent 4 checks back to her last month, which caused her to incur a late fee, which she is refusing to pay. I consulted an officer of the business bank. Her bank did online research and sent her 2 letters requiring compliance before refusing her payments that still showed an incorrect payee name. I do not see how I would not be on solid ground to refuse these payments, but I'm not an attorney. So first off, yes, you can reject a payment. It is if a payment is submitted in an improper name, simply because of the problems it'll cause you cashing that payment. But I certainly wouldn't wait on 4 checks. And I certainly wouldn't wait for multiple instances of where this is happening. If this does occur, naturally the best way to do it is to confront it sooner rather than later. But you do have good ground to reject these payments and to charge additional fees, especially if you had given prior written notice of this default. So, hopefully this all clears up. It sounds like this particular tenant is being obstinate. I would point to the provision in the lease, continue to paper this situation with written notice that you're delivering to the tenant, so that if ultimately you do have to evict, you can demonstrate to the court you went over and above in notifying the tenant of these defaults and that ultimately she refused to comply with the basic description in the lease. Janice writes, adult children 20 years old need to be in the lease and do a background check. Yes, even 18 years old is getting close. Now, you might say, well, they're a senior in high school or they're a college freshman. They're also adults. And so if they're coming in on a new lease, then yeah. And here's one way to protect yourself. Let's say you're signing a lease and mom and dad have a 17-year-old, a 12-year-old, and a 5-year-old. And they sign a lease and they're there and they renew the lease every year for 5 years. Well, guess what? That older child, if they're still living there, they've been an adult for some time. And at a certain point, once they've become an adult, it's imperative on you to add them to the lease or say, look, he's no longer there. That's fine. He can be removed as an occupant. Or he can stay only as an occupant as long as he's under 18. But once he's an adult, it is helpful for you to have someone living on the property who is an adult join in on the lease and share in the liability. And certainly if they're coming in brand new, any adult children should also sign the lease. Whether they're 20, 30, or 50, get all the adults living on the premises to sign. Again, if they're extremely old or they lack capacity due to some mental issue or health issue, then again, those individual adults can be excluded, but for the most part, any healthy adult, able-bodied, should be on the lease when you're taking in new tenants. Okay, next, Vanessa Sweet asks, we filed the local jurisdiction's eviction process for non-payment of March rent. We have our court hearing scheduled for next week. Is there something we need to make sure to do to keep our case strong since there is no rent for April as well? Well, here's the thing. You're entitled to rent for the month of April, but the court might limit you to rent up until the day of trial. So if, for example, you have a $1,200 a month rent, nothing was paid in the month of March, and your trial is on April 10th, exactly 1/3 of the month, you could ask the court to award you the full $1,200 for the month of April, but the court may limit you to 1/3 of that, which is $400. Not bad, but you want to mention it. Nothing has been paid for the month of April, and you'd like a judgment for rent owed in the month of April. The judge may say, I'm going to limit you to 10 days. So be prepared before you go to court with that number, whatever the number of days are represented up until the day of trial. If the tenant is still in possession, ask for that, if not the entire month from the court, because the entire month is owed as of April 1st. So some judges will give you the whole month. Some will only give you up until the day of trial. Kanaparthi Sabitha asked, I have a landlord where tenant didn't pay rent, $7,000. The house was damaged and had repair costs, $5,000. We filed eviction, she vacated, but the house damage was a lot. He's looking for help. Well, again, the issue comes down to two main questions. Can you find this tenant? Where is this tenant now living? Where are they working? Because if you can't find them, you can't serve them with an additional lawsuit. But more importantly, does this tenant have the capacity to pay? And if they do, then yes, absolutely. If you can find them and they have the capacity, go after this tenant, go collect everything you can from them. They have harmed this landlord. But if not, unfortunately, this is an expensive lesson learned. Unless the rent is $7,000 a month, you really don't want to wait as the rent stacks to such a high number. My recommendation to landlords is 7 days. If within 7 days of the month, the tenant has not paid 100% of what is owed, notice to vacate. Begin the process sooner rather than later, and I guarantee you, you'll have fewer losses. Kapil Goyal writes, tenant filed for bankruptcy 1 day before the eviction hearing. What next? Well, unfortunately, a bankruptcy does stop an eviction in its tracks, and the court cannot move until the bankruptcy case is either dismissed or comes to a full end. So many times, tenants are just in desperation going to file a bankruptcy as a way to stop the eviction. And they might end up leaving. If they leave, yes, you can recover possession and take control back of the house. In fact, the eviction trial may no longer matter to you. But if they're still there, you're going to want to follow the bankruptcy. And if you're unsure how to do that, you might want to consult a bankruptcy attorney to help you. But you're going to want to follow the bankruptcy until you know for sure that bankruptcy has been kicked out and dismissed or has come to an end. You may or may not get any money out of it, but if you want possession, you're going to have to wait for the stay in the bankruptcy, which is there from the start of the filing. That stay is lifted. It is possible in the middle of the bankruptcy to have someone enter in a motion for that stay to be lifted so that you can recover possession from your rental property. But for that, you're going to want to consult a bankruptcy attorney. Janice adds, if your firm drafts a lease agreement, can I still use a realtor to find a tenant and not use the HAR lease? Also, do you have a bilingual staff? I definitely have a bilingual staff. I myself am bilingual. I can speak Spanish. If your firm drafts a lease, yeah, you can use whatever lease you want. Your realtor is subject to you. Remember, they're your agent. So they have to follow what you do. So yeah, I mean, they're representing you, remember. And especially if you're going to manage your own property, they just have to learn how to use your lease. But yes, you are allowed to use whatever lease you want. A. Brown writes, Mr. Ernie, can a tenant get out of an eviction through rescission? Maybe. So there are provisions in the property code that allow a tenant to unilaterally terminate the lease. However, unilateral termination has to happen before a rent default. And most of the provisions in the code say that this doesn't apply if you are delinquent in rent. So can they get out of an eviction through rescission? Not if you had a valid claim for eviction. Probably not. But can a tenant rescind a lease? Yes. There are things that landlords do that sometimes rise to the level that allow a tenant to simply unilaterally terminate the lease because the landlord is in breach. That is entirely possible, but it's not typically a defense to a valid eviction. So I hope that was clear enough. Certainly I would need more facts, but you are welcome. And the last question, Adele Villarreal asks, can someone really steal your house title? No. Can they file a fraudulent title? Yes. But a fraudulent title is void on its face. So they didn't really steal anything. You might have to go through some red tape to get that cloud off of your title. But unless you validly transfer title to someone, a fraudulent title is really of no effect. Now, you're going to want to stay on top of that if you find out that someone filed a fraudulent title claiming to be you. They've caused a cloud there, but certainly if you file a lawsuit to restore the validity of your title, that fraudulent document is of zero effect. You just want the record to reflect that. So again, a fraudulent title is void in the eyes of the law, but you've got to mention that because on its face, it looks valid, right? Property from A to person B. If you are A, then it looks like you signed that. But as soon as you step in and say, and I would file an affidavit in the property clerk's records immediately saying, nope, I never signed that. That's a fraudulent title. While you go through the courts and get that title removed, then a judge can sign an order saying, nope, this is invalid. It was never valid and never had any force or effect. But yes, can someone file a fraudulent lien or a fraudulent title document? They can, but technically it's of no effect. It is void on its face. So, all right. Well, I thank you all for joining. I thank you for those of you who contributed questions here, those of you who contributed questions live in the chat. For those of you sticking around, I appreciate you sticking around. For those of you who watch later, I hope you enjoy what you've heard in today's chat. I will be back next week, probably. Yeah, you'll get notices in our Facebook group. And I'll make sure to notify people on YouTube. But until next time, landlords, happy leasing.